So, welcome to this consultation event on the Institute of Faculty of Actuaries proposals related to the duties and responsibilities of actuaries working for trust-based prepaid funeral plans. My name is Penny Shepherd. I'm a lay member of Regulation Board. And for the last 18 months or so, I have been the chair of the working party that has been developing these proposals. So all the members of the working party, the other members of the working party, have been actuaries working in the area, but I've been chairing it as a lay member, and I took over from Sir Philip Moore, who was previously the chair of Regulation Board and who was the initial chair of the working party. So I took over when he stepped down, although I've been a member of the working party since it was formed. So as you would deduce from that, these proposals have been some time in the cooking. But we hope that we now have produced a cake that will meet with your approval. But clearly part of the consultation process is to ascertain that, to get your comments, and then update and modify the proposals as needed, if that is needed, depending on what the response of that consultation is. This is the first of two consultation meetings. This is the consultation meeting in London, and there will be a similar meeting in Edinburgh next week. With me on the platform, I have on my right Eleanor Turnbull from the IFOA staff team, who has provided the very capable secretariat for the working party. And in a minute, she will be running through the background to the working party's work and summarising the proposals in the package before we move into the Q&A area. And on my left, I've got Elissa Elshner. Have I got that right? Yep. In the end? Yes. Who is from the Professions Public Affairs function, and who will therefore be able to comment on some of the parallel work we've been doing, looking at the surrounding regulatory framework, and equally well making sure we don't say anything about that we shouldn't say in public at this stage. So after Eleanor has spoken, we'll move into the Q&A session. If you could hold your questions until that time, so that we can then use the roving mic, which therefore means that your comments will be audible for the recording. So meanwhile, over to Eleanor to take us through the process.
Thank you very much, Penny. Can everyone hear me okay? So we'll go through the format generally of the consultation meeting itself. So Elisa is driving the slides for us this evening. We'll go through the background to the consultation and its historic GN38 development, etc. Then we look at the current regulatory framework that's in place at the moment, turning then to look at the concerns that we have about the current regulatory framework and what we're doing and where our locus sits in relation to that framework. Then we'll go on to the new regulatory package itself, next steps, and then, as Penny has said, question and answer session at the end. We've got our very capable working party members here, mostly in the front here, who'll be able to answer some questions as well. So in relation to the background, as Penny had mentioned, this has been a long time in the making, and I know you will have different experiences with this particular set of regulatory work. So bear with me, some of you have got much more knowledge about it and some just interested in it. So a bit of background. Obviously, funeral plans enable people to plan ahead and give them peace of mind, or their bereaved relative peace of mind, by having the cost of their funeral covered in advance. We have a proposal to introduce some new regulatory requirements for actuaries working on prepaid funeral plan trusts, but this, as I said, continues from an already established process. From about September 2003 through to October 2011, the then actuarial profession and the then Board for Actuarial Standards, now the FRC, John Instance at the back there, had put in place a guidance note, which some of you might remember, snappily GN38, on prepaid funeral plan trusts. As with the GNs at the time, they contained both ethical and technical guidance. The FRC then introduced its technical actuarial standards regime. Therefore, the current funeral plan's technical actuarial standard came into force in October 2011. It contains very technical guidance, and that leaves the remit for the IFOA to deal with the ethical side of things. And in order to ensure that the ethical regime relating to funeral plan trusts is appropriately covered, the IFOA had set up a working party. Again, the members are here in the front, so you can wave if you wish, consisting of our experienced practitioners, independent lay members, including Penny and Sir Philip Moore, and to see whether or not we actually should take regulatory action. We don't take regulatory action just for the sake of it, despite what you might think with all our actuarial profession standards. We needed to make sure it was proportionate and appropriate. And the recommendations of that working party is the consultation package. This involves an actuarial profession standard itself, guide for actuaries, guide for trustees, and additional continuing professional development and support. But we'll turn to that later. The package is, as the slide says there, intended to ensure that actuaries working in this area, a very niche area, are sufficiently experienced. They're aware of the particular responsibilities, particularly in relation to plan holders themselves, and are adequately supported and assisted by the IFOA in undertaking the work. The funeral planning market is also, as you will know, a growing one. There's currently £1 billion now invested in funeral plans. This is trust-based and insurance-based. We're not entirely sure, the Funeral Planning Authority, and we've had discussions about how much is insurance-based and how much is trust-based, not entirely sure where the split is. With about 900,000 plan holders, again, mixed between trust-based and insurance-based plans. And again, the plan holders are typically from lower socioeconomic backgrounds. The IFOA doesn't intend, at the moment anyway, to produce any material relating to insurance-based plans, so that's outside our current locus. So moving to the current regulatory framework, and again, I'm sure a lot of you will be very familiar with the very snappily named Financial Services and Markets Act 2000 Regulated Activities Order 2001, otherwise known as the RAO. Plans may be excluded from Article 59 if the plan provider uses a prepayment to purchase a whole life insurance or uses a trust which meets the requirements of Article 61B of the RAO. Article 61B's requirements are summarised on the slide there. You need to have a written instrument establishing the trust. More than half of the trustees must be unconnected with the provider, allowing for some independence. The assets of the trust must be managed and by an independent authorised trust fund manager. The annual accounts must be audited and prepared, so we've got auditors and accountants into the mix as well to add to the actuaries, any profession starting with A by the looks of things. And the assets and liabilities of the trust must be determined, calculated, and valued by a fellow of the Institute and Faculty of Actuaries at least once every 3 years. It is a requirement of Funeral Planning Authority registered providers that there is a valuation that's required more frequently. In addition to the RAO, actuaries are also subject to and must be aware of and follow the Actuaries Code, which is the current ethical benchmark for all actuaries. The Funeral Plans TAS, as I'd mentioned before, and 3 other TASs, data, modelling, and reporting. I mentioned at the start we have concerns about the current regulatory framework at the moment. And again, the salient points are summarised on the slide here. Actuaries are guided, obviously, by the terms of the trust deed when carrying out an assessment of the trust's assets and liabilities, but there's no clear guidance laid down beyond those terms. The RAO is very, very coarse on detail there. There's also no requirement that the trustees act on the results of the actuary's assessment or on the actuary's advice, or that the actuary should even take any further action if they produce their assessment and find a shortfall or find some problems with the conduct of the trustees in running the trust. Additionally, if the actuary does discover a shortfall in the assessment of the assets and the liabilities, if the plan provider is not an FPA registered provider, there is no entity which has the locus to accept complaints about the trustee's conduct. Obviously, if a plan provider does become insolvent, the plan holders will be affected. Again, this depends on whether or not the plan provider is registered with the FPA or not. If they are a registered provider with the FPA, then other plan providers who are fellow registered providers with the FPA can be called upon to actually assist with providing the contracted funerals of the insolvent plan provider. It's known as the pledge. However, if they're not an FPA registered provider, or the FPA registered providers can't help in that particular situation, And currently, the only recourse for the plan holders is to actually bring legal proceedings, and no one likes lawyers anyway. We believe, though, that our current consultation package is a proportionate and reasonable one in the current regulatory environment and in the public interest. As part of the IFOA's Royal Charter function and as a professional body, we are required to act in the public interest. Additionally, professionals occupy a privileged position of trust, which brings in obligations to act impartially and in the public interest themselves. This is particularly brought into focus in the area of funeral plan trusts, as actuaries have been specifically named by Parliament and the legislation as the professionals who are appropriately qualified and ethically sound enough to undertake an assessment of the assets and liabilities. What we can't do is attempt to compensate for the gaps in the current regulatory environment. But this is another dimension where the IFOA's public interest function is activated. Elisa, we are to speak up on matters affecting the public, and in this regard, we've raised our concerns with the current regulatory environment with various parliamentarians and HM Treasury, as we believe it's those institutions who need to consider whether it is necessary to change the current legislative environment to better protect the public. And you can question Elisa on that at the Q&A session. So a word on our new regulatory package now. As I said before, it consists of a number of elements. The first one is APS Z1. We couldn't think of another name for it at the moment, so if anyone's got suggestions, there was a suggestion that F1 sounded at least kind of fun and speedy, but not sure. So suggestions on the name would be appreciated. This is a short, high-level ethical standard to supplement the provisions of the Actuaries Code itself, the funeral plans TAS, and the other relevant TASs. Generally, what we've tried to do in the standard is to have key provisions to try and at least alleviate some of our concerns. These relate to information gathering mechanisms, provisions, and escalation mechanisms. Now, you should have a copy of the standard there in front of you. So I'll quickly just run through the provisions here. Paragraphs 2.1.2 to 2.1.7 and 2.2.1 to 2.2.3 combine both information gathering provisions and escalation mechanisms. These provisions are intended to ensure that, in working with the trustees, an actuary is aware of the plan holder's contractual entitlements, draws to the attention of the trustees any changes of circumstances which might affect those entitlements, is satisfied that there are systems of control in place to ensure plan holders aren't misled as to their expectations, and draw any concerns that the actuary might have to the attention of the trustees. The provisions are designed to stimulate discussion and scrutiny of actuarial work and to improve the trustees' understanding of the relevant issues and what they expect of their actuary. The Working Party believes that an actuary should be clear in their dealings with the trustees in relation to the assessment of the trust's assets and liabilities as to what the actuary's understanding is actually of the plan holder's contractual entitlements. In order to be able to do this, actuaries need to make themselves aware of all the relevant material that might actually bear on the entitlements. This will obviously involve the marketing literature and the contract between the plan provider and the plan holder, as well as the governing documents, the plan trust deed, of course, being one of the key documents here. The actuary should also notify the trustees if there are any changes in the trust's operations or circumstances, which again might mean the plan holder's contractual entitlements are affected. Again, this is a crucial aspect of the actuary's function in advising the trustees and helping the trustees to fulfill their responsibilities to the plan holders. Additionally, paragraph 2.1.2 tries to ensure that the burden of notifying plan holders of changes to their entitlements falls on the trustees rather than the actuary, or if it missing out altogether. Paragraph 2.1.1 requires an actuary on accepting an appointment to have the right to personally present a report to the trustees should the actuary deem it sufficiently necessary. Again, we're hoping this provision will ensure that the actuaries can speak up and address matters of significant concern and importance to the trust before it goes pear-shaped, and to ensure that the actuary is not fettered by the trustees or by the existing trust scheme rules, which is the more likely possibility. Again, we hope this encourages full and frank discussion between the trustees and the actuary. Paragraph 2.2.4 is designed to ensure that the actuary is satisfied that there are systems of control in place intended to ensure that plan holders are not misled as to their entitlements. And if the actuary has any doubts about the adequacy of these systems, he or she should draw them to the trustee's attention. Paragraph 2.3 addresses the situation where an actuary has produced the assessment of the assets and liabilities, but believes there is a material shortfall in the assets, or that the plan provider's contractual obligations are significantly higher than the liabilities of the trust. Again, the RAO doesn't give any guidance as to what is to happen if this occurs. This provision envisages that at a first step, the actuary, having drawn the position to the attention of the trustees and the plan provider, should try to encourage the trustees to take appropriate steps to alleviate the shortfall. If, however, appropriate remedial arrangements have not been made within a reasonable period of time, the provision then envisages that the actuary will report the position to the plan provider. As a fallback mechanism or a secondary measure, if the trustees and the plan provider have not put in place appropriate remedial arrangements, again within a reasonable period of time, it's proposed that actuaries should report their concerns to the auditors of the trust or the plan provider, and if the plan provider is an FPA registered provider, also then to the FPA. The working party doesn't believe that an actuary would report in anything other than extreme circumstances, where, for example, following very protracted discussions, no attempt has been made by the trustees and or the plan provider to actually remedy the shortfall. In any case in which a report such as that would be made, an actuary would be required by paragraph 1.2.3 of the standard and also under clause 3.6 of the code itself to speak to any successor actuary regarding what had happened. So that's the standard. The other part of the elements of the package include a guide for trustees and a guide for actuaries. The guide for actuaries is supposed to provide substantial non-mandatory guidance material on funeral plan trusts, and it's with great thanks to the Financial Reporting Council, John Instance and Faye Dice in particular, for helping us get this piece of material across. It contains very detailed guidance on the relevant regulatory provisions. There's lots in there about the TASs applicable to these trusts, in addition to practical advice and tips on working with such plans. The guide also identifies some of the risk areas which actuaries should be aware of before accepting an appointment, particularly because this is such a specialised niche area. And we recognise that there are a variety of ways in which these trusts are structured. So again, the guide encourages you to think about the various ways that these trusts can be established and the operations of plans and how that might actually affect the advice that the actuary gives. The guide for trustees, and I understand we have our independent trustee who helped us with this guide as well, but I won't name you if you don't want to be named and shamed, has helped us to come up with a guide which is again designed to set out for the trustees' benefit the professional obligations falling on actuaries. Again, we're hoping it's going to stimulate thought and discussion and scrutiny of actuarial work and to allow trustees to understand what an actuary hopefully does with these plans. And no IFOA regulatory package would be complete without additional professional support. So in order to complement these regulatory provisions, we will also be providing CPD opportunities and training in relation to trust-based funeral plans. And a relatively new funeral plans member interest group was created in 2014. Thank you to Michael Harvey, who often drives this one forward, for members and interested non-members to discuss funeral plan related matters. It's an online forum, and if you want any further details about that, please come and see me after this. So what will the standards and guidance not achieve? Unfortunately, we can't close the current regulatory gap in the RAO, which doesn't provide a mechanism by which actuaries can actually raise their concerns about shortfalls in the assets and liabilities. That's why we're seeking to get some change through Parliament and HM Treasury. We also can't change the content of the marketing literature sent to plan holders. A note on this, FPA registered providers' marketing material is actually scrutinised, and there is a new consumer rights bill currently going through Parliament, which I understand is to come into force, I think, later this year, and it's going through some of its final readings at the moment. I think the final bill is due to be completed, I think, in March this year. This probably will have an impact, actually, on the content of marketing material. Two things to look out for is that the bill envisages that marketing material may actually vary the terms of consumer contracts, so the actual contract between the plan holder and the plan provider. And businesses then also need to be very clear about how they present key provisions and pricing terms then in their contracts. What we also can't do is provide a statutory ombudsman type regime for complaints about funeral plan trusts to be considered in an independent forum. We also can't require trustees to make up a shortfall in the trust, although with the standard itself, we can speak up as much as we can to try and alleviate that problem, but we can't compel trustees to do that. We also can't compel trustees or lawyers, whoever's dealing with the underlying trustees, to actually ensure that the trustees are amended to ensure that there are sufficient assets and that so that the contracted funerals can actually be paid. On a positive note, though, what we hope it will actually achieve is, as I said at the start, actuaries working in this area are sufficiently experienced and supported, ensure that actuaries have the right information gathering and escalation mechanisms available to actually undertake a proper calculation, ensure that actuaries can report their concerns to the most appropriate people, be that regulators or the other professionals involved in actually running the trust, setting out, hopefully for the trustees' benefits, the professional obligations falling on actuaries, seeking also, obviously, to address the risks to the public. In terms of our next steps, we've deliberately chosen to keep the consultation, close the consultation on Friday the 13th to go with the funereal plan. And the paper summarising the responses that we received through the consultation will be produced in spring 2015. If the proposals are supported and are to proceed, then we anticipate those being effective in the second half of 2015. So I'll now leave the floor open, and you can get rid of my dulcet tones, and if anyone's got any questions and answers.
Yes. I think possibly just to add to that, Eleanor, the issue of speaking up and escalating, what we have identified in the standard is a requirement to escalate to the plan provider, to auditors, to the FPA where the plan provider is an FPA member. But the key point is that because there isn't a regulator with appropriate locus, there is no ability to escalate to a regulator, and that's the gap that we clearly can't address within the proposals. The other thing to say is some people have asked about guides produced by the profession, and I mean it is an increasing practice by the profession to produce background non-mandatory guides to assist both actuaries and other stakeholders to consider some of the issues involved. And indeed, for example, 2 years ago in 2013, the profession produced a guide for employers of actuaries on conflicts of interest that I think has been very well received. And so it's very much in that tradition that we are proposing a guide for trustees and a guide for actuaries. And probably the final thing to say is that Eleanor is, of course, in a position to be able to be negative about lawyers, being a lawyer herself. Those of us who aren't lawyers, I'm sure, wouldn't share her views. But so over to you. Your questions. There is a roving mic, I think. I don't know who is going to rove with it. Are you going to rove with the roving mic? Right. And when you have the mic, if you could tell us your name and if appropriate, where you're from or your interest in the subject before raising your question or comment. Questions, comments?
There we go.
I'll begin. My name is Graham McCausland, and I've recently been appointed as the new Chief Executive of the FPA.
Congratulations.
Some of you will know I also happen to be an actuary. I'm not sure whether that's good or bad, but I thought it might be worth reminding people what the FPA is about. Basically, the FPA is not a membership organisation. You have to apply to be registered with the FPA, and you have to go through a registration process that involves scrutiny, and that's an annual process where things like trust accounts, the provider's accounts, marketing material is basically sent to us and reviewed. The coverage of the market's about 90 to 95%, I think is what the slides said, and that model has worked pretty well since its inception. The FPA works constructively with the FCA, and I think in particular on situations where people aren't complying with the REO, which is another issue that's not up there. I think the FPA's general view on the consultation is we welcome most of it. The APS, I think there's a lot of sensible things in there around, and actually I suspect most of the actuaries that are involved with trust are doing these anyway. I think where we run into a difficulty is where you cross the border of the trust and we start talking about costs of funerals. And actually, to pick up something you said earlier, I think we've got to be very careful when we're talking about providers becoming insolvent and trusts becoming insolvent, because they're different things. But as an example, what is the cost of a funeral? Well, that's a question that I guess it would be good if actuaries did ask their provider what they thought the answer to it is, but there may be a range of answers from the marginal cost through the wholesale cost through the retail cost, and I think we've got to be very careful when we use words like cost, what we're actually meaning. The area where I guess we are more concerned, and I think it goes on to, sorry, I should say the guidance stuff we believe is very helpful. There's an issue of how that gets out to trustees and things like that, but maybe individual actuaries can help with that, and maybe actually we can help with that.
That would be great.
The whole wider regulation piece on the public interest bit, I think we have a bit of an issue on the focus on trust-based plans. The issue is exactly the same on insurance-based plans. There is literally no difference. There's an asset, and that either meets the cost of the funeral or it doesn't. And I think the profession needs to be a little bit careful. It's not seen as just sort of protecting its own interests rather than actually genuinely protecting customers' interests. The gap, we call it a gap, exists in both types of plan. I would say there is and I'm led to believe, partly through discussions with John, that providers should be allowing for any gap anyway in their accounts, and that's certainly something we'd expect to see in accounts, and maybe that's part of the answer as to covering the gap. I think we welcome this whole process, actually having more people understand the training side of things. We believe is good. We'd like to help be part of that. And I think it's important that we get the industry involved in it rather than just have actuaries involved in it. That said, it needs to be kept alive. Yeah, I think
no pun intended.
Very good. The danger is we have a little bit of CPD post the consultation, and everyone gets happy,
Yep.
does their hour and a half, and moves on. And maybe it's something that between the profession and maybe with the FPA, we can actually work to figure out how, in conjunction with the working party, that moves forward. I think my final comment would be, I guess, to help resolve some of the issues, it would be nice if there were any actuaries involved with people that are not registered with the FPA, they think about registering.
Thank you very much, Graham. That's really useful, and big congratulations on your new role. Have you actually taken it up yet?
Yeah, about 2 days ago.
Right. Okay. Excellent. I mean, first thing to say is we've been very grateful to the Funeral Planning Authority for their constructive discussions with us, and we had a very useful session this autumn with Graham's predecessor that I mean we were certainly very grateful for and that we thought was very useful. You know, we very much hope that the FPA does put in a written response as well to the consultation, including, you know, any detailed suggestions for areas where you think that, you know, where there are, you know, details that may be of concern to you, so that we can make sure we consider those as, you know, appropriately as part of the consultation response. I mean, the thing to say very specifically, and I suppose it's a matter close to my heart as the public interest member of Regulation Board and somebody who is therefore not an actuary, is that there is no suggestion in this that we believe that that insurance-based plans are in some way safer or more appropriate than trust-based plans. The issue is that the trusts associated with trust-based plans are areas where where actuaries have specifically got a responsibility under the RAO, and therefore it's the area that the Working Party has addressed, and indeed that the Funeral Plans TAS and the previous guidance note address. And therefore, we have not looked specifically at insurance-based plans, but if there is a sort of sentence or a footnote or something that we ought to be putting into the documentation to make that clearer, please point that out to us.
It's about making sure that there's a clear picture and not a distorted one.
Yeah, and I think we share an interest absolutely in that.
I guess taking it to its extreme, that there isn't any actuarial guidance that tells an actuarial function holder in an insurance company that he needs to look through to the cost of providing a funeral for the plans that he's selling. So I understand the difference in the trust situation, but actually the reality of it is almost exactly the same. And I think we just need to be careful that it's not seen as this is the actuarial profession covering itself on the back of a public interest story. If it's a public interest story, then let's have the full debate rather than a bit of it.
I mean, I think from what we would take the view, which it says that that an insurance company, if you're looking at an insurance contract, then you're looking at the assets of an insurance company. Whereas if you're talking about a trust, you're talking about a ring-fenced amount of money. But when you go outside of that, the issues around the relationship between the holder of the prepayment and the plan provider and the funeral director, then it's very much the same. Well, it is the same. I think I'm right in saying. Sorry, Andrew.
I think do
you want to remind us who you are?
Yeah, I'm Andrew Chamberlain. I'm a member of the Working Party. I'm also the Deputy Chair of the Life Board of the Institute of Faculty. I think the other important thing to remember is that an insurance-based plan is subject to the financial services regime, and therefore the marketing is subject to the Financial Conduct Authority rules, and they are the relevant authority therefore, and the Institute of Faculty doesn't have a role because there is no specific relationship between the insurance company actuaries and the funeral plan. What the exemption is there is for a whole of life insurance contract used for funeral planning. So it falls entirely within the FCA regime.
I might be wrong in this, Andrew, but I'm not sure that's actually correct. I mean, you'll excuse me for having 2 days worth of experience, but my understanding is that it's a funeral plan that's sold, which isn't subject to the FCA requirements.
The insurance contract is.
Yeah, but it's not the individual who takes out the insurance contract, it's the provider who takes out the insurance contract.
If I leave it to you two to debate the details of that, and John Instance from the FRC is also expressing an interest
the FCA at the back.
is also expressing interest in the topic. However, at a practical level, in relation to these regulatory proposals, they are specific to prepaid funeral plan trusts. Yeah. And so therefore the predominant issue is if we've made it clear enough that in addressing that issue, we are not expressing any opinion of the relative merits of trust-based plans and insurance-based plans.
I think that there's nothing in the documents that make me worry about that. It's if you want, almost the discussion outside of the documents, where I think the profession is careful.
Yeah, yes, and we seek to be careful.
I'm Steve Wallace from Dignity. We're a plan provider. Just on that debate, I'll just add a couple of points, which is we work with a lot of whole-of-life plan providers, and whole-of-life plan providers, you buy a life policy, and that life policy is valued to pay out a cash sum, and the value of the cash sum bears no relation at all to the escalating cost of funerals. So those guys are sleepwalking, frankly, into a big problem. and they can choose to ignore that or pretend it doesn't exist if they want to, but it does exist. And a 1% difference in those assumptions over a compounded period of 20 years is enormous. The other thing I'd add, which, and I mention this because you specifically pick it up in your details, is that you talk about that there's no real compensation scheme, and there's the pledge, but whole of life funeral plans are not covered by the Financial Services Compensation Scheme, and most people assume they are not. And so actually whole of life providers have less protection than a trust member that's a member of the FPA. They have zero protection under their policy if the plan does not pay out and the policy proceeds are not there, or they disappear in their entirety. A member of the public has zero protection. So there are some genuine issues that maybe this board should turn its attention to when it does look at those things.
Thank you. Ah, we've got the microphone. Thank you. Other comments? Yeah.
I spend most of my time dealing with trust-based providers, and I think they would argue that kind of whole-of-life policies aren't funeral plans at all. To me, a trust-based funeral plan is you have a voucher that gets you your funeral that you've prepaid for. End of story. Whereas a whole-of-life policy is an insurance policy, as I think Steve said, pays out a sum of money that goes towards meeting your funeral costs. So it's completely different to this kind of voucher system now I call the prepaid funeral plans.
I think what I'm taking away from this is that the profession possibly might wish to promote more debate on this issue. You know, as part of the educational and CPD or even possibly public affairs function. Equally, what I would say is that this particular regulatory package is specific to trust, you know, to funeral plan trusts. You know, so sorry to be sort of closing down on that debate.
I'll just add one last point, which is that's also wrong.
Actually, nothing wrong.
There are many whole of life policies now that are specifically designed to cover funeral costs, and they are sold as funeral plans. And those whole of life policies are not just paying out a fixed sum assured; they are guaranteeing to cover funeral costs. And so they're sold by Golden Charter, by AXA, by Legal and General, by the Co-op, amongst others. And there are vast numbers of those sold, and they are, in most cases, are not being valued appropriately.
Yeah, just come back. I think there are some where the funeral director has promised. Where the funeral director has promised to do the funeral in return for getting the whole of life policy proceeds paid to them. So maybe that is a funeral plan, but the risk is with the funeral director rather than the plan provider. No. Okay.
So, an interesting debate here, but probably a debate to have in another place.
Jeremy May from PwC. Certainly a final point from me on that would be when the Institute is talking to parliamentarians on this, will the sort of the total, you know, some of the issues that have been raised today be brought up as well on the life side as well as the trust side?
We have made it clear that, or we have sought to make it clear in any conversations that, you know, as with the package, we are raising concern about trust-based the trust-based plans. We are not seeking to express an opinion about insurance-based plans, but that we are not suggesting in any way that trust-based plans are better or worse than insurance-based plans. I think going, you know, the question to ask back to Graham and his colleagues is what it would certainly be useful to know is that if parliamentarians or others then say, okay, so who do we talk to about insurance-based plans to understand them, where do we point them?
I don't want that, thank you. Michael Harvey, member of the Working Party. My concern with insurance-based plans is where is the actuarial involvement? There is no actuary involved in that whole process of selling the contract, providing the funeral at the end of the day. There's no actuarial assessment throughout that whole process. So how do we get involved?
I think the underlying answer to that would be yes, but they are an insurance company. The insurance company is overall regulated, and the insurance company has an actuarial function holder. But that's part of the debate, I think.
That's not talking about the contract between the individual and the funeral director.
Can I just make one last point on this subject, if I may? You mustn't confuse two entirely different things. There is a funeral plan that invests in a whole-of-life policy. And there are policies of insurance where part of the marketing message is you can use it to help fund your funeral.
Yeah.
The first of those is a prepaid funeral plan, and there is somebody providing funerals associated with it, and they invest the money in an insurance contract. And that's not the same thing at all. And so that's why we've had slight disagreements about what happens with the different types, because they do operate in a slightly different way. One case there is a funeral provider involved, and the other case there isn't.
But the underlying question, I think, in relation to the public affairs area remains the same, in that, Graham, do we hand over your name or what?
Absolutely.
Yeah, that would be grateful. Thank you.
I think we just need balance, and
Yeah.
I do worry. Sorry, it's a bit late, but I really do worry that to say that we've got a concern from a public interest point of view and only tell half the story is for me a dangerous thing to do.
Yeah, exactly. Any other comments on the package? John, did you have anything to say?
Would you please? Yes. My name is John Instance, Financial Reporting Council. Just briefly on the last point, the FRC has produced a risk perspective document about areas of work that have a significant public interest, where actuarial work is involved, and clearly it comes out today, and the profession have raised it, funeral plans are an area of public interest, and I think it's been raised by the person from Dignity, some insurance companies, and as you said, Penny, actuaries are very closely involved in insurance companies, in designing the products, in setting the liabilities. Well, actually, I know the directors are responsible for the liabilities, but nonetheless, the actuarial function holder is providing significant input there. So clearly, there is a wider public interest, and I think I'm going to take that back and sort of plug it into my risk perspective document. I know we have a meeting on the 27th of January at Staple Inn about risk perspective, and I think it might be an issue worth discussing. I certainly will discuss it with the FPA and others about how we take that forward within our view of the risk perspective. And maybe, it has been addressed by the Joint Forum already. Maybe we can have some feedback on that. Coming back to the package, yes, I think the FRC welcomes the package. Yes, we were and have been pre-consulted on it. We think it is generally a good thing. I suppose our concern now is that it actually something at how it gets delivered. And I think Graham mentioned that. It's around how is this CPD going to be delivered. There is a risk, we've got these great documents, so everybody reads it when it comes out, and then it just gets left on the shelf and forgotten. And so what sort of processes do the profession have to ensure that high-quality CPT is delivered to its members? How trustees are kept informed so that they can challenge and provide adequate scrutiny to the work of the actuary. I suppose I was slightly disappointed, in fact, with the final document about the document on the trustees, because I'm not really sure. It described what the actuary does. Well, that's great, but it didn't actually provide. And I think perhaps what could have been helpful is to provide some questions and what sort of things should you be challenging the actuary about, because a lot of the trustees won't be experts, and maybe it's the role of the profession to provide some of that. Things. Well, you should. It's all very well saying, talking about, they're going to make an assumption about the investment returns. Yeah, great. So they make one. Okay, what should I be as a trustee who's probably not an expert on long-term investment assumptions? And again, I come back to our risk perspective document. There's whole stuff on we are concerned about what actuaries say about long-term investment assumptions. You know, what should they be saying? You know, one of the questions you might ask is, what happens if we're in a Japan-type scenario and investment returns are only 1% for the next 20 years? Because I'm sure the actuary isn't making that assumption. You know, so I think perhaps the trustee document can be built on, I mean, to say, here are some questions you might like to consider asking, and these are the reasons why you should.
Thank you. That's very useful. And certainly, I mean, picking up on Graham's point earlier, we will very much welcome help from the Funeral Planning Authority to help disseminate the trustee guide when when it is finally produced. Other questions or comments, gentlemen?
Hello, my name's John Howe. I'm actually the independent trustee that helped draft that. And in fact, my question isn't really, or my concern, my observation isn't actually about the last point. I think there's some sort of valid comments there. It's always reducing it to the layman's level of what where trustees are, what they should be probing. So I rather support those last comments. One, just from an independent trustee point of view, one of the issues one's always looking at is the duplication of role between your different professional advisors. And bearing in mind, if you sit on a trust these days, you've got the actuary, you've got the lawyer, assuming you have a lawyer, but you've got the lawyer. You've also got the auditor to the trustees. You've also got the auditor to the plan holder. You've got the actuary, possibly your actuary, but possibly another actuary giving advice to the plan holder as well. And there is, from an independent trustee point of view, one gets slightly concerned when you see an overlap. And there is a slight overlap here, which occurred to me just simply in your presentation, Iona, which is the duty or the emphasis on the actuary to look at the systems and structure and report on those. I have to say, as an independent trustee, I would expect, and indeed currently where I'm involved, we expect the auditor to carry that function. And I get slightly concerned about that function being duplicated elsewhere and the inevitable professional tit-tat that goes on once you get into these overlap areas. And that's just a thought that's occurred to me listening to your presentation.
Do any of the actuaries on the working party want to comment on that? Andrew?
I think to be fair to Eleanor, in a presentation you do tend to slightly summarise. The wording in the standard talks about the member must ensure that should he or she consider that the systems of control in place to protect the plan holder's interests may not be adequate, he or she must draw this to the trustees and the plan provider's attention. It doesn't say go and do a great big detailed investigation to look for it, but if you find that it's not adequate, then you should say something. Which I think is importantly different.
Yeah. Yes. I mean, Michael, anything to add to that in practice? What do you find that people do in practice?
I would have said that the auditors tend to concentrate much more on the financial systems, whereas the actuary needs to spend a little bit more time on the data recording systems, the membership details and so on. So there will not be necessarily that much overlap. But where the actuary finds that there is something that looks odd, then it's his duty to raise it with the trustees accordingly.
That makes sense. Right. I'm seeing other nods in the front row. Excellent. Any other questions or comments? So, Eleanor, anything you want to add in summary before I ask Alyssa?
I think the points that, John, you've raised about CPD and making sure that it remains current and approachable and practical and relevant, I'll definitely take that back to internally within the IFOA to make sure that we do that. But we are mindful of that, certainly. So that's my final comment on that point.
Thank you. Alyssa, anything you want to add? But certainly we take on board the substantive debate in relation to to the issue of trust-based funeral plans versus insurance-based. So thank you all very much for your input.